I'm talking for just a few minutes. So, I need you to focus. I got a perm, which made it look like a haircut. Hey, that's more observant than some people are. All right, so let's talk about this. This unit's going to be handled a little different. It's going to be project-oriented. So you need to be thinking about who your partner will be. I do need, if anybody knows Kyle Binko and is willing to work with him a little bit more virtually, that'd be awesome, because then he doesn't have to take a topic all by himself. Okay? So let me know about that in just a minute when we pick projects. Need to talk a little bit about what's important about this issue. As you guys know, in the battle for ratification of the Constitution, we divide into two camps, Federalists and Anti-Federalists. The Federalists say, this Constitution's awesome, the structure protects people well enough, just ratify it. What do the Anti-Federalists say?
It does not protect from abuse of government.
Okay. And so what does it need?
Bill of Rights.
It needs a Bill of Rights, okay? So the Anti-Feds are going to say it needs a Bill of Rights. And who is that Bill of Rights intended to protect us from?
Government. National government.
The national government.
Well, as was interpreted by the 1830s case. Yeah.
Okay.
He was originally intended for the government to intended the Supreme Court decided it was for that.
Well, but was it?
Well,
Do you think it's just about the Supreme Court, or do you think it was intended to protect us from the national government?
Well,
Some of the stuff says, like, it specifically does not mention national government, while some of it does. So why would they just leave national government out if they meant it?
why wouldn't they want their citizens to be protected from state governments? Oh my gosh.
Amendment 1.
Oh, through the Constitution.
Wait, what?
First Amendment. First Amendment.
That one says from
Read the
national
first 5
government.
words.
Second one does not. Right?
Not Article 1. Amendment.
There's a lot of amendments.
It's the one in the front.
There's a lot of them. Okay.
There's 27.
Congress shall make no law respecting.
Okay, stop. Congress shall make no law. What is the... Thank you, that's all I needed.
Instead of shall.
That's what it said.
The Constitution sets out the limits on what level of government? The federal government, okay? So the reason the Supreme Court's going to interpret that is because the Constitution itself is a limit on the national government, not on the states. The states aren't, other than defining federalism in Article 4 and denying a couple of things like nobody can grant titles of nobility, the states aren't part of that document. It's about the national government. So if you're going to amend that document, you're applying to the national government. Besides, most of the states had bills of rights. Okay? So Madison's argument against it was what?
States have bills of rights, and they can make it for themselves.
No, actually. He said if you make a list, etc.
Text against it will specifically try not to avoid
Yeah,
things.
if it's not on the list,
Well, that's why they have the 9th Amendment, right?
he won. Okay, but his argument was, if it's not on the list, government is going to use that as a loophole. They're going to say, well, but that's not on the list. You don't have it. So yes, he threw in the 9th. Okay, so the 9th Amendment, I think, is one of the most important of the amendments because it said these are not all of your rights. You have others. All right? And then he threw in the 10th and said, everything not in here is reserved to the states. Okay, so we're going to roll along just fine. You're going to have the case of Barron v. Baltimore in the early 1800s. Who knows what that was about? You might have done that one.
Was that the 1833?
Was it that late? I thought it was a little earlier.
Was it the one about selective 1833?
Was it 1833?
Yeah, that's the one that was like, it is, all this stuff applies to the federal government only.
Yeah.
Yeah, what was the case about?
There, he called Baltimore. I did that one.
Good job.
Woo!
Don't worry, I'm pulling up OEA right now.
She's pulling up OYA. She's not pulling up the collaborative document where she did it. She's pulling up OYA.
Well, I would pull up
But you know it's the same copy.
So you would agree that Madison is a
Oh,
genius?
yeah, eminent domain.
I absolutely, Jimmy's my friend. He is a genius.
He is a genius.
Okay. He absolutely was brilliant. And he's on my fantasy dinner party list. I would love to be able to sit down and talk to the guy. Okay? Barron v. Baltimore deals with the issue of eminent domain.
Yeah.
Which, what is that, Livy?
That's the one where the government can seize land if they feel like it's beneficial.
Okay. And so what's the problem here?
I'm confusing this with the one of New England. I'm confusing those cases.
Okay.
Property, which is what's
Yeah. The city of Baltimore took his wharf space. It's part of the wharf in the harbor.
Oh yeah, and then he said that because it's connected to the ocean, then it doesn't apply.
No, actually, they said, you know what? You're wrong. Okay. I can give her a hard time. I birthed her. All right. Baltimore is who took his land. Is the city of Baltimore the national government? F minus minus. No, Chris. The Baltimore is part of Maryland, and so therefore they said no. I'm sorry. Sucks for you, but you're not protected in this instance. Okay, I hope Maryland has something, but we can't help you. And that is going to be the prevailing interpretation until 1925. Okay? Now, after the Civil War, we passed the 14th Amendment. You still got that Constitution over there, Garrett?
No, you put it back.
I was trying not to steal.
Fail, fail, fail. 14th Amendment. Roman numerals, oh my gosh. I want you to read the 14th Amendment. We're going to roll over here so that... I want you to read what's important. Here we go, Garrett's reading.
It's all important because it's all American. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No
Okay,
state-
stop. That's addressing what problem?
Well, I thought more important.
Citizenship.
Yeah, that's what
Okay.
Trump and all them are trying to take away.
Yeah, okay, yeah, let's forget Trump. He's an entertainer. He's not going to get elected.
He's so funny though.
Okay.
Rand Paul is also.
This is dealing with
Get your woman.
the problem that occurred out of Dred Scott, where they said Dred Scott was not a citizen, so therefore he didn't have jurisdiction to the federal courts. Okay, so it's dealing with that. All right, go into the next part.
No state shall make or enforce any law which shall abridge privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny to any person without his jurisdiction the equal protection of the laws.
Okay, that's the important part. All right, go back. Reread that more slowly, and y'all tell me what you hear in there.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law.
That's like the equal protection.
Nor deny to any person within his jurisdiction the equal protection of the law.
That's the equal protection thingy.
Privileges and immunities.
Okay, thank you. Now, to the best of my knowledge, and I'm going to give myself a disclaimer because there might be something in there. To the best of my knowledge, they really haven't dealt with this one, this whole privileges and immunities thing. That really, we hadn't done much with that. What the court has done, though, are these two things, due process and equal protection. And they're saying states.
That was the correct answer to at least 2 questions on the test, right?
Probably.
What was?
States cannot deny you due process of law. What is due process of law? Oh, it's not just trial. Bigger.
Trial by a jury of one's peers.
That is an aspect of due process. But what's the big thing about due process? Why do you have due process?
Everybody should be treated under the law.
It's about fairness and being treated fairly. Okay, so it's about fairness. And there is substantive due process, which is an important vocab term for you guys to know. So there's substantive due process, My Law Academy peeps, what can you tell us that is?
Oh, I don't think we've gone over that.
Partial. Wait.
Substantive due process?
Yep.
Yeah, he talked about it in the video.
Give me a second. Give me a second.
No, you are not Googling this one. This is the idea or concept that you must be treated fairly. Okay? It's the concept and the idea that you must be treated fairly. And then there is procedural due process,
Courts.
Olivia, you sound like a baby bird.
which is the procedures
Yes, the court.
that are taken into place. Well, it's not just courts. What else would it be?
Briefing.
If you sit on the laughing when you took off.
True.
She's like, that's not my daughter anymore. Why do you got that table here?
I don't know.
She doesn't like us.
I think we're distracted.
Maybe things like being read your rights.
The Miranda rights, that's Miranda v. Arizona.
Okay, well, whoa. Okay, finally, A plus plus. We won't give her 2 pluses actually because she doesn't know the year. 67. Okay, so it's not enough to know that you have rights. In Miranda v. Arizona, they said you had to be told what they are. That would be procedural due process. The fact that you have them is substantive. Being told what they are is procedural. Make sense?
Yes.
Okay. This is all fine and good, but I got to get back to the original point here. Give me that eraser, please. Just throw it, and I won't catch it, and it'll be amusing. Ah! Okay. I know. Y'all have no idea how big a deal that was. Okay. Shut up. Okay.
Not in the way at all.
They were in my way. Okay. So, using the 14th Amendment, starting in 1925, in the case of Gitlow versus New York, they began a process called incorporation. What does incorporation mean? Connor.
It means bringing the rights against the states on a case-by-case basis.
Well, let's not get to the case by case yet. Yes. It means that this, right here, doesn't just apply to the national. It also applies to the states.
Isn't that common sense?
And the vehicle,
Okay, Thomas name.
the vehicle that they use to drive those rights to the states to is the 14th Amendment that Garrett just read to us that said, no state shall deny its citizens due process of law or equal protection of the laws. They're not going to apply it until 1925, which it was passed in like 1868, 69, something like that, right after the Civil War. They're not going to apply it for another 50 years or more, but eventually they're going to. Now, they had 2 options. They could do what's called total incorporation, which would be so much simpler and you would have far fewer court cases to deal with.
Yep.
Total incorporation would have been like them saying, hey, states, you dummies, this applies to you too. They didn't do total incorporation. Why didn't? Well, hang on. I'll tell you why not.
Backlash from the states.
No. Because some of them, if you think about what's in the Bill of Rights, is there any logic to applying, for instance, the Third Amendment to the states? Quartering of troops.
Yeah.
That has been incorporated against the states.
No, it has not.
Dang it, I really.
Third Amendment has not been incorporated to the states because states don't have armies.
Wikipedia lied to me.
Okay? Wikipedia does that sometimes. Okay? So states don't have armies.
Like, how are they different?
So you don't want to incorporate that down to them because what's the point? All right? The 10th Amendment, states' rights. Not a reason to incorporate that down to the states.
But you could have just
Second Amendment.
Bill of Rights and told the
The Second Amendment is not going to get incorporated until 2010.
When they try to take our
Right to bear arms. I know, somebody in Alabama didn't know what the Second Amendment was. Just kick him out of the state.
Go back to your communist country without your
Okay, so focus. I really feel bad for Kyle watching this stuff virtually going, oh my gosh. All right. Instead, they practice something called selective incorporation. Selective incorporation. That means on a right-by-right, case-by-case basis, as they get them, they're going to decide what applies to the states and tell the states how it applies. Okay? Right by right, case by case. And sometimes, and that's not amendment by amendment, that's right by right. Okay, that's a significant difference. Because like the Fifth and Sixth Amendments both have 50 million things in them. So does the First. And they're very nuanced. So it's right by right, case by case, which is why you have so many cases to do. There's 100 cases in this unit.
So is that,
Okay, which is why y'all are working in groups. Well, actually there's 80. I reduced it.
so is that like the we'll cross the bridge when we get there?
In a way, it's we'll cross that when we get there. And in the other way, it makes sense. It's a little frustrating when you're having to learn all of it, but it makes sense. Because the court is a court of review, and they're reviewing the facts of a specific case, and they've never been one who move on beyond the facts of that specific case, which is what they would need to do for total incorporation. Again, there were those at the time that argued for total, and it would make our task much easier, but that they didn't choose to do it that way. Okay? This is a huge... Does everybody understand this? Ask me questions as we're starting, what I mean by selective incorporation. Because kids aren't getting it. They keep sending out extra features, how to teach selective incorporation. They keep sending out stuff from the College Board, and they keep sticking it on the test every year. It's been in free response like the last 3 years in a row in some way, because kids just aren't getting it. So,
yeah, just go over it once more. Just like speak through it.
well, you're going to learn it because that's what you're going to do in this project. But selective incorporation.
Start with incorporation.
Well, you tell me what incorporation
I don't
is.
remember. That's why I want you to explain it.
Oh my gosh.
Let's go back to right.
She's failing today. All right. Who can explain to me what incorporation is?
Someone like Connor did. Didn't it bring the Bill of Rights to the state level?
Yes. Okay. So it's saying the Bill of Rights doesn't just apply to the national government. It also applies to the states. Using what vehicle or car?
14th
The 14th Amendment, which has two important clauses. Due process and equal protection. And they're going to do it how?
through selective incorporation.
Yes,
Which is-
selectively.
Right by right basis.
Okay, so for instance, the Sixth Amendment are your trial rights. So they're not going to just say, oh, states, by the way, you need to give a fair trial in all these ways. As they get a case, so as they got the Scottsboro Boys case, Powell v. Alabama. Who knows what that case is?
I remember that.
Do you know what it is?
No.
It's an Alabama case. I love Alabama cases. Okay, so you got...
It always involved picks and whiskey.
Well, no, I don't know if there was any whiskey, but there was definitely racism going on here. So they're on the train. There's 7 black boys and 7 white boys on a train. They get into a fight. The white boys win and throw the black boys off the train. Okay. Oh, I'm sorry, wrong. Back up. The black boys won through the white.
Discrimination.
Sorry, got to get it right. The black boys won, threw the white boys off the train. The 2 girls, the plot thickens. The 2 girls who were with the white boys cry rape. They arrive in Scottsboro, Alabama. Within 48 hours, all 7 black boys are tried and convicted and given the death penalty for rape, because rape was a death penalty offense back then. They saw an attorney when they arrived in court. That was it. In court. And they appealed. By the time the Supreme Court got it, because the Alabama Supreme Court, of course, upheld the conviction, etc. By the time the U.S. Supreme Court got it, I think 3 of them had already been convicted. We used to convict pretty fast, too. 3 had already been convicted, something like that. The Supreme Court decided to hear the case. That kind of suspended all action on the others. They overturned it. They said that they had not been given adequate access to counsel, that the Sixth Amendment requires that you have the assistance of counsel, and that they had not actually had the assistance of counsel, so therefore they needed to be retried, and they added a special condition. Basically, if you were a black man in the South, the assumption was you weren't going to get a fair trial, so they needed to be extra careful, and that this was a capital offense because rape was a death penalty offense, but they added conditions, basically. They said, okay, this is the selective part. In the instance that it is a capital offense, states you must provide counsel. If it is a black man in the South, you must provide counsel, and more than just like when you show up in court. 2 or 3 years later, we have the case of Betts versus Brady. This guy's white in Georgia. He's not black, not given counsel, but not given an attorney. He gets convicted. He turns out to be illiterate.
Huh?
We add another condition under which you ought to be given an attorney. It's going to culminate in Gideon versus Wainwright in 1963, where they're going to say, regardless of whether it's capital or petty or whatever, that is an important right. People need, the system is too complex for the average person to be able to adequately defend themselves in a criminal case.
Wasn't that the case with the kid in Florida that tried to defend himself and was successful?
Well, he wasn't a kid, but yeah. He tried to defend himself and he did not do an adequate job because the system's too complex to do that. And so they extended it across the board. You have the assistance of counsel even if the state has to pay for it. Florida's argument in that case was, well, 90% of our prison population was convicted without benefit of counsel. You're going to throw our system into chaos. To which the Supreme Court basically said, really? That's your argument? Sorry. Suck it up and figure it out. Okay. And they did. They had to figure it out. All right? Okay. So we got this basically?
So for Selective Incorporation, who's the one deciding which one applies to the case? To the Supreme Court?
Supreme Court. Okay. All right. Yes.
So for private bankruptcy that's involving Selective Incorporation, what's a go-to case to go to?
For what?
Selective Incorporation.
Just in general?
Any?
There's going to be a lot. We're going to do 80 cases in this unit. Okay? All right. Let me describe your project to you. All right? You're going to work with a partner. And you're going to take one of the rights that's listed in the project assignment, and they're all correlated to sections of chapters 4 and 5. All right? And we are doing 2 things. We're doing civil liberties, but we're also doing civil rights. Okay, so we're not just looking at criminal rights and privacy and that kind of stuff. We're also looking at the way minority groups have been treated and different types of minority groups. Okay, so you can, I thought about making y'all draw from a hat, but I think I'm just going to let you duke it out. It's going to be, like Survivor or something. On a piece of paper, each copy can only be claimed by one group. So, first come, first serve and duke it out. Shh, listen. But your task is going to be, and I've given you some parameters. I've given every group 5 cases that relate to your area, and then you've got to find 3 more. It used to be 10 total. It's going to be 8 total. So you've got to deal with at least 8 cases that have incorporated the rights that you're talking about. Okay? You're going to have to be able to explain how they do it. And you're going to give a 20-minute lesson to the class, each group. It's 20 minutes. How you choose to do that lesson is your choice. I encourage you to really think. PowerPoints are easy, but they're not necessarily the most effective way to teach something. I want you, in your partnerships, think, how would I learn this best? And it might not be through a PowerPoint kind of lesson for 20 minutes. It might be something more interactive. I'm leaving that decision to y'all. I just want you to consult with me ahead of time. If your lesson requires that people are going to need to read something or do something before the lesson, then I need that by Thursday so that I can have it distributed to the group. We have got to start them Friday. Okay? We have to start the present, and we need to do 2 a day. That's why I said 20 minutes. I'm going to be kind of strict on the 20 minutes. We've got to get 2 done a day to finish all 10 by next Thursday. It's got to be done by next Thursday, both because it's the end of the 9 weeks and because I won't be here on Friday. So I'm having a spinal block. So it's got to be done by Thursday. All right? She's never home. No, I don't. She's never home. Okay?
It's underlying behavioral issues.
Yes, there are. So, it's got to be done by next Thursday, so I've got to have 5 days. I know Thursday night is a game. I know for some of you that's a bigger challenge than it is for others. So it'd be great if the ones that is not a challenge for would volunteer to go Thursday or Friday, okay? So that we can get that done. Again, you're deciding how you do it. You're deciding what visuals you use, what activities you use. I'm here to guide you. On the side, you need to be reading chapters 4 and chapters 5. And what I've done, there's not going to be a test on this. This project is your test. Okay? You're going to take quizzes on your reading, though. You're taking quizzes on your reading. All the chapter 4 quizzes are in. Chapter 5, I'm halfway through. Okay, and those are going to be loaded in. You take them on your own, on your honor. All right, they're supposed to be actual quizzes, not open book or anything. That's on your time. Okay, and so and what your prep might be I'm talking about the material in section 4.3, so I need everybody to have read 4.3 before we come to class. That might be what your homework is that you say you need people to do. You might find an article that's interesting that would lead to being able to discuss something with the class. You should have read the section and then read this article, and we're going to talk about it. You guys decide how you're going to do your lessons, okay? And do it in ways, and just ignore Garrett. He's not going to give you any homework because he doesn't like homework. So he's not going to give you any. No, we can't. Okay.
That's the homework.
Questions? Questions? Shh. Excuse me. Yes, there are guidelines in there. There's a project description, and then that tells you what your presentation or lesson needs to include. And then there is specific for each topic where I gave you the cases and everything. You also have to prepare, and this should be done collaboratively between the two of you, you have to prepare an abstract. Basically, I'm getting rid of, and some of you have already done the civil liberties cases. You've already did some of those, even though we weren't supposed to do those till later. I'll give you credit for doing those, but you're not going to do the collaborative document because you'll be doing this, and you're going to provide your abstracts on a wiki page. But your abstract would be like that for your 8 cases that you're doing together. Okay? And I want to put them all on the wiki page so that later we all have all the cases to reference to help us prep for the exam. Okay?
Do we have class time today?
You have class time for whatever the balance of today is, tomorrow and Thursday.
Okay.
Yes.
When do we choose our...
Right now.
Can we have...
Okay, hang on. I'm going to put them